I am Keith Van Heyningen, and this is Tucson. Let's go talk about illegal aliens, shall we? Gotta hit the button. Well, welcome to Tucson, where when an illegal alien screams, everybody listens. It's a bit of a comedy bit, you know.
Yes, yes, I do. Yes. They're just all out of order, and all the other lightweight stuff. I'm gonna get it over with quick. I'm gonna go back to Reno Ranch and back.
All right, I need a motion to return to study session. We've got a motion and a second to return to study session. All in favor of returning to study session, say aye. Anyone opposed? What is the council's pleasure for item 2?
I'd ask for a motion to proceed as discussed in executive session.
Got a motion and a second to proceed as discussed. Any further conversation? Hearing none, all in favor say aye. Aye. Anyone opposed?
Aye. No.
Okay. Okay. Let's move on to item 3. Council members Romero and Ulick have requested discussion regarding the enforcement practices and policies of TPD relating to SB 1070. Council member Romero.
Thank you, Mr. Mayor. I requested today's study session item. As you know, yesterday the ACLU of Arizona filed against South Tucson Police Department for an alleged violation of Fourth Amendment rights under SB 1070. I think that this mayor and council, the conversations that we have had, the position that our chief of police has had publicly in regards to our stances against SB 1070 and the reasons that we have opposed it, both the chief of police and this mayor and council, seems as though they're playing out. And so for me, based on the history of decision-making of this mayor and council, we took a very public stance against SB 1070, and so did our chief of police, Roberto Villaseñor. We, the mayor and council, took a very public stance against HB 2281, even if it was not concerning city of Tucson issues. We took a very public stance about the lawsuit that we submitted along with Flagstaff regarding SB 1070 and the undue burden that it would bring to our city and our police department. And finally, we took a position to be a immigrant welcoming city. So our public policy stances have been very clear in how we want to be perceived as a city. We want to make sure that as a city, we stand for the rights of every single person that resides within the city of Tucson. And I think that there's been several concerns that that community has seen and brought to our attention. And I think it's important. We've had several conversations as a community. We've had several forums, and a couple of them, our city attorney, talking specifically about September 25th, 2012, our city attorney, our chief of police, and other organizations, including ACLU, came together in a public forum to talk about how we as a community can move forward with the law as it has been delivered after the Supreme Court heard it and delivered its its opinion to Arizona. So I think it's important that we come together, that we have conversations, that if there's any community groups, anyone in the community that has questions about it, that we have a conversation and a dialogue about it. So I'd like to introduce Mike Rankin and our chief of police, Roberto Villaseñor, to talk about the conversations that we have had recently. And we've had since SB 1070 passed the state legislature and signed by Jan Brewer. So let's have a conversation about where we are, and then I'd like to invite James Duff Lyle from the ACLU of Arizona after Mike Rankin and our chief Villaseñor have an opportunity to talk about what we've done so far, and then work towards steps moving forward.
Mr. Mayor, members of council, Councilmember Romero, thank you for that introduction. Just note that we tried to include considerable information in the Mayor Council memorandum in advance of today's discussion, because obviously there's a lot to go over here. I do intend to go through that information, but I'm going to try and do it in somewhat of a summary fashion since you've had the written materials for a few days now. Fundamentally, I wanted to just quickly review what the status of the law is following the Supreme Court decision in the summer of 2012. I also want to go briefly over the general orders and the language that already exists, currently exists within the general orders, and talk about what general orders are. And then I think we can cover the issue of U visas relatively quickly. So with that said, in the aftermath of the Supreme Court decision and some of the other litigation that has been going on since SB 1070 was signed into law in 2010, we have certain provisions that remain in effect and undisturbed by the courts, and we have other provisions that have been held to be invalid by the courts. And I included those within your material, but it's worth going over a few now. First, under the category of provisions that are still in effect and valid following the Supreme Court decision, 1051A, which is the prohibition against city officials or agencies from limiting the enforcement of federal immigration laws, and there's a related provision I'll mention later. stopped, detained, or arrested if there's reasonable suspicion to believe that the person is unlawfully present in the United States. And then the second provision with respect to arrest, requiring verification of immigration status of any person arrested prior to releasing that person. In the context of 1051B, I do want to note that there are two what I'll call exceptions. With respect to the reasonable suspicion inquiry, it's to be conducted where practicable and where the inquiry would otherwise not interfere with, hinder, or obstruct an investigation. And when you look at the general orders incorporate those exceptions and define circumstances that can amount to those exceptions and things that the officer should consider in the view. 1051C through E requires state officials to work with federal officials with regard to persons who may be unlawfully present. And then subsections F through K, in particular subsection H, I believe, provides for the private cause of action, which again goes back to the general prohibition against a city official or an agency from adopting a policy that restricts or limits the enforcement of federal immigration law to less than the full extent permitted by federal law. What subsection H does is it allows a private cause of action where any legal resident could sue the city if we were to have a policy that violated that prohibition. And under that section, it also establishes mandatory minimum penalties that would be imposed by the court. 500 minimum $500 to up to $5,000 per day that the policy remains in effect after a challenge is filed, as well as the city being responsible for all court costs and attorney's fees from the prevailing party.
And the similar is on the other side of the equation, right? On either side.
No, it's only if the policy is found to violate that prohibition. It does not trigger the ability, does not provide for any penalties for the city to recover if the city would prevail or attorney's fees. But as you know, certain provisions have been thrown out by the courts as well. I listed those in the memorandum. It included primarily the sections under Title 13 of the criminal statutes, which was the legislature's attempt to create separate state law crimes where those areas were already incorporated within federal law. So, for example, the provision creating a crime for the failure to apply for or carry papers, which initially people referred to as the show me your papers, because this is actually the requirement that says that the documents had to be carried with you that's been found invalid. The section creating a crime for unauthorized alien to solicit, apply for, or perform work. A separate crime creating a criminal offense for transporting or harboring undocumented persons. And another provision on its face would have authorized warrantless arrests under certain circumstances. Those sections were all thrown in under the Supremacy Clause, essentially on the theory that federal law preempts the state from legislating in those particular areas. Another important thing about the United States Supreme Court decision was that although the provisions that I identified as still being in place, and particularly 1051B, the court ruled unanimously was not preempted by federal law, and so the court left it in place. But the court did note that its decision did not preclude future challenges based on the implementation of the provisions of 1070. And I use that for shorthand when I say the provisions of 1070 because, as you know, after 1070,